What is the process of mediation in New York personal injury case? Imagine this. You have been injured in an accident and well, you are already dealing with pain and medical bills. The thought of a lengthy court trial looms over you. But what if there was another way to resolve your case quickly and with less stress? In New York, personal injury cases often involve mediation, a process that can help both parties reach a fair settlement without going to trial. So, how does mediation work and why should you consider it for your injuries case? Let's dive into the detail. Hi and welcome back to our channel. In today's videos, we are going to walk you through the mediation process in New York personal injury case. If you are wondering what mediation is, how it works, and whether it is right for your case, you are in the right place. What you will learn first is what mediation is and how it works in personal injury case, the benefits of mediation over going to trials, who participates in the mediation process, how to prepare for mediation in your personal injury case, what to expect during a typical mediation session, common challenges and how to overcome them, what happens if mediation does not result in a settlement, the role of an attorney during mediation, how mediation can impact the outcomes of your case. First is mediation. Let's start with the basic. What exactly is mediation? In simple terms, mediation is an alternative disputes resolution process where both parties in a legal case meet with a natural third party called a mediator to try to resolve their difference and come to an agreement. The mediator does not make decision or offer legal advice. Instead, they facilitate a conversation between you and the other party, usually the defendant or the insurance company, to help both sides understand each other's perspective and comes to a mutually agreeable settlement. So, why would you consider mediation instead of going to court? These are several advantages to mediation in a personal injury case. First, mediation is usually much faster than going to trial. Well, court case can take months or even years to resolve. Mediation can often be completed in just one or two sessions. Next, it is typically less expensive than a lengthy trials, as you avoid many of the costs associated with going to court. Mediation is also confidential. Unlike court trials, which are public, this means that any settlement or discussion you have in mediation are private, which can be a huge benefit. Lastly, mediation tends to be less stressful because it is a less formal process. You don't have to worry about the unpredictability of a jury or the pressure of being cross-examined in court. Who participate in the mediation process? Now, let's talk about who is involved in mediation. Of course, the two main participants are you, the injured party, and the defendant, usually represented by an insurance company or their attorney. You also have your attorney present to guide you through the process and ensure your best interests are protected. The defendant will likely have their own legal counsel there as well. And finally, there is the mediator, who is a neutral third party trained to facilitate the conversation and help both sides come to an agreement. How to prepare for mediation in your personal injury case? Preparation is key to making mediation successful. Here is what you need to know about getting ready for your mediation session. First, gather all relevant documents related to your case, medical records, bill, and any evidence that show the impact of the injury or your life. This will help your mediator and the other party understand your position. Second, think about your goals. What outcomes are you hoping for? Are you just looking for compensation for medical bills, or do you also want compensation for lost wage, pain, and suffering? Lastly, be prepared to negotiate. Mediation is a two-way process, so you will need to be ready to listen to the other side's perspective and final common ground. What to expect during a typical mediation session? Once you are prepared, what happens during the mediation session itself? Here is a step by step breakdown. First, the mediator will introduce themselves and explain the ground rules of the session. This is a neutral sitting where both sides are encouraged to express their view. Next, each party will have the chance to make an opening statement. This is your opportunity to explain how the injury has affected your life and why you believe you should be compensated. After that, the mediator may separate the two parties private causes where each side meets separately with the mediator to discuss settlement offer and concessions. Finally, the mediator will bring the parties together again to try to come to a final settlement. If a settlement is reached, it will be put into writing and signed by both parties. Common challenges and how to overcome them. While mediation can be great way to resolve a case, it is not always easy. There are some common challenges that can arise during mediation. One of the biggest challenges is stubbornness on both sides. Sometimes one party may be unwilling to compromise or accept a fair settlement. If this happens, it is important to stay patient and open-minded. Remember, mediation is a process of give and take. Your attorney will help you stay focused on finding a solution that works for both sides. Another challenge is the emotional toll, especially if the injury has caused a lot of pain or financial stress. Be sure to learn on your lawyer and support system for advice and guidance during this tough moment. Unfortunately, not all mediation result in a settlement. So, what happens if you cannot reach an agreement? If mediation does not lead to a settlement, the case can still proceed to court, where a judge or jury will decide the outcomes. However, many personal injury cases settle after mediation because both parties understand the risk and cost of going to trial. Throughout the mediation process, your attorney plays a crucial role. Your lawyer will guide you through each stage of mediation, help you understand the strength and weakness of your case, and ensure that your rights are protected. They will also negotiate on your behalf, making sure that any settlement offer is fair and in your best interest. So, now that you know what mediation is and how it works in New York personal injury case, you can decide if it is the right option for your case. Mediation offers a way to settle dispute without the stress and cost of a trial. But like any legal process, it requires preparation and understanding. If you are facing a personal injury case and considering mediation, make sure to consult with an experienced attorney who can guide you through the process. Thanks for watching today's videos. Don't forget to like, subscribe and leave a comment if you have any question. Until next time, take care.